you're thinking of moving to Des Moines or expanding your real estate portfolio, contracts are the bedrock of every property deal, but they don't have to be overwhelming. Whether you are a local buyer or a first-time investor, understanding these agreements is crucial to making profitable decisions. Imagine being able to spot the key terms that could make or break your deal when investing in Des Moines. Stay tuned to the end of this video as we cover these 7 elements a real estate contract must have to keep you out of legal trouble. Welcome to the channel. My name is Blake Alewelt, owner of the Bravo Ridge Group. If you are tired of being at the mercy of realtors and attorneys when it comes to contracts, this is the perfect video for you. For some new investors, reading a real estate agreement can seem like reading a foreign language. The contract is typically full of confusing legalese that doesn't make any sense. But navigating contracts in real estate transactions is crucial for becoming a successful investor because it is utilized in every transaction. You'll never escape it. The term real estate contract refers to several types of agreements or contracts to close a transaction. So whether you are buying, selling, transferring, or leasing property, a legal binding document is always part of the sales process. Therefore, it is vitally important you understand how real estate contracts work and the common terms used in property agreements. The reason for this video is to provide a comprehensive overview of different types of real estate contracts. You will also learn common real estate investing terms so other agents or investors can't take advantage of you. So what is a real estate contract? A real estate contract is a legally binding agreement, typically involving 2 parties in a real estate transaction and outlining each party's responsibilities and obligations. The contract is usually a written and signed document. Real estate agreements typically include terms such as the purchase price, earnest money deposit, contingencies, closing costs, inclusions and exclusions like items that are staying or leaving with the home, and closing date, among others. Because a real estate contract is legally binding, it's vital to understand its different aspects. Once you sign the contract, you are bound to the terms. Therefore, the terms of the contract will have a significant impact on your rights and obligations in the deal. In all cases, a contract in real estate transactions protects both parties. The only way to terminate the agreement is typically if contingencies are in place, such as the satisfactory inspection in the timeframe, financing, or a sale of a previous property go through for the buyer, or if the contract expires itself. If one party breaks the terms of the contract, the other party can take legal action to recover losses, such as the earnest money or damages. This is how real estate contracts work. A real estate contract is usually the result of lengthy negotiations. Although you can find templates for sales contracts or lease agreements online, both parties must agree on the finer details. The contract only becomes binding when both parties accept the offer by signing the agreement. Each contract must meet the following main requirements. Negotiation. First, both parties discuss acceptable terms to the transaction. These can include purchase price, rental amount, security deposit, contingencies, closing costs, and closing date. The offer. The first party prepares the real estate agreement with the initial offer. They then sign it and give it to the second party. Then comes acceptance or counteroffer. The second party can now accept, counter, or fully reject the offer. A counteroffer could involve modifying or adding contingencies, renegotiating the purchase price, or including a deal sweetener. Making a counteroffer invalidates the initial offer. And if the offer is rejected, the contract is canceled entirely. Then there's signing. When both parties agree on the details of the contract, either accepting the initial offer or agreeing to the counteroffer, they both sign the agreement. Then there's something called consideration. The last step to legalese the deal is consideration. This term refers to something of value exchanged in the deal. Common forms of consideration are cash, a promise to perform, or property in exchange. No consideration means that the contract is not enforceable. In addition, there are several other criteria for a real estate contract to be legally enforceable. These are the following. Number 1, signatories must be of legal age, not mentally impaired, or forced or coerced into signing the contract. Number 2, the contract must have legality of purpose. In other words, it doesn't have or involve illegal activities. Number 3, the contract must identify all parties involved and the subject property. Here are the most common types of real estate contracts. The 4 most common types of real estate contracts are a purchase agreement, lease agreement, real estate assignment, and a power of attorney. However, depending on the type of deal, contracts could include more specific agreements for non-traditional properties, buying through a real estate agent or directly from the seller. The purchase agreement, also called a sales contract. A purchase agreement outlines the terms when buying or selling a property. This is legally binding contract describing the obligations and responsibilities of the buyer and seller. Let's go through the main components of a purchase agreement. First being identities of all parties involved, the address of the property and its description, the purchase price, inclusions and exclusions like we explained before, earnest money deposit, all the contingencies, the party responsible for which closing costs, possession date and terms, the closing date, and signature of all parties involved. And there are 3 types of purchase agreements depending on the type of real estate transaction. There are the state and association purchase agreements. This real estate contract is used when buying a property through a real estate agent like myself. The contract is based on local realtor guidelines. Since I'm an agent here in Des Moines, we use forms that comply with our local and state laws. For us to use any other purchase agreements, say for creative finance forms like a subject to deal, then we have to have them drawn up by a state-specific attorney. Then there's the general purchase agreement. Like the state association purchase agreement, this type of contract is used when buying a property directly from the seller, or like a FSBO. Then there are property-specific purchase agreements. Suppose you are buying a plot of land, a mobile home, or other non-traditional type of property. In that case, you use a property-specific purchase agreement. Ultimately, these agreements protect the buyer and seller in a real estate transaction. It is meant to clearly state what happens during the transaction to keep both sides honest and stick to the plan. Therefore, it's necessary to take your time to read the contract and understand its terms before signing. So let's go over the lease agreement. A lease agreement is a real estate contract that outlines the terms and conditions for renting a property. The agreement is between the property owner or landlord and the tenant. Typical terms of a rental agreement include the following: monthly rental amount, security deposit, the party responsible for utility payments, house rules like the maximum number of occupants, pets, and smoking, the landlord or property manager and the tenant's original signatures, and provisions related to lease renewal, termination, and default, conditions of the property and any repair or maintenance responsibilities. Lease agreements are used for residential and commercial properties. Remember that. Then there's the power of attorney. A power of attorney is a legal document used in real estate transactions to authorize one person to act on behalf of someone else. A power of attorney is necessary when one party cannot physically or electronically sign the real estate contract. Reasons to use a power of attorney document are usually due to the following circumstances: physical or mental incapabilities or age preventing the person from signing, the person is hospitalized or has another illness preventing them from actually signing the document, and the property owner manages investment properties through a company or third party. An example of when these are used are in estate sales, when people get a little older or their family has a power of attorney to sign on their behalf if anything were to happen. Now let's go over real estate assignment contracts. A real estate assignment contract is a legal agreement used in wholesale transactions, where a wholesaler assigns the rights and obligations of a purchase agreement to an end buyer in exchange for an assignment fee. The wholesaler enters into a contract with the seller to purchase a property at a certain price and terms, and then assigns that contract to an end buyer for a higher price or terms, and keeping the difference as profit. Contract assignment in real estate is common when a homeowner wants to sell without a realtor or sell their property to a cash-only buyer. The wholesaler acts as the middle person between the homeowner and that end buyer. There are a few important things to note regarding assigning a real estate contract. The investor doesn't obtain title to the property. Assignment contracts don't involve selling or transferring the property directly. The assignment of the contract doesn't show up in the title chain. One additional thing to note for this is that as of July 1st, 2024, per the Real Estate Wholesaling Consumer Protection Act, wholesaling is no longer legal in Iowa without the use of a real estate agent or having a license yourself. You can check Google for the finer details of this. Before we go through what has to be in a contract, I ask that you hit the like and subscribe buttons down below so we can better tailor our content specifically for you. So what are the essential elements of a real estate contract? A real estate contract is only legally binding if it meets specific criteria. One of the basic elements of a legal contract is that all the terms and clauses must be clear, unambiguous, and specific. Contracts can lose their legal validity if terms are too vague or uncertain. For a real estate contract to be legally binding, it must contain the following 7 elements. You're going to want to write these down. Number 1 is the intent to create a legal purpose. All contract terms must adhere to existing laws. Number 2, authority and legal capacity. The party signing the contract must be at least 18 years old and legally competent. Number 3, the offer. This must be a definite offer for the other party to accept. It cannot be open to interpretation. Number 4, acceptance. Any rejection or counteroffer renders the contract invalid. Acceptance occurs when both parties sign the contract. Remember that it can be amended later if both parties agree to change some or all of the terms. Number 5, consideration. Money, goods, or services must change hands for the contract to be legally binding. This is also called consummation of the contract. Number 6, certainty. The contract must contain unambiguous terms. These relate to the purchase agreement, contingencies, property address, and closing date. Number 7, payment terms. The manner of payment, financing terms, earnest money deposit, property taxes, closing costs, and interest payments, in the case of deferred payments, must be clearly stated in the real estate contract. It's good to note that a verbal agreement in real estate can also be binding if it contains the key elements of a valid contract. Just be aware of that and don't agree to anything, even if it's verbal. Who creates a real estate contract? The buyer's or seller's real estate agent or a real estate attorney typically draws up a lease or purchase agreement. You can also create your real estate contract using an online form or template. However, because of the complexities and legal obligations involved, it makes sense to have a real estate professional licensed to practice law draft a contract. In most cases, if you draw up a contract that isn't certified by a real estate attorney, it may increase your liability if parts of it are found unlawful. Here are a few common terms that you should know. Getting started in real estate investing typically involves learning a new language, legalese. But the good news is that the meaning of the terminology and phrases related to real estate transactions are not difficult to master. Here's a list of the common terms real estate contracts use. Parties, the individuals or groups involved in a real estate contract. Sales price, the purchase price of that property. Financing, the method used to finance the real estate transaction. This could include a cash or a home loan. The legal description. The legal description of the property should include the address, the lot, block, and subdivision. It's also helpful to provide detailed written descriptions of the property. These can be a little confusing. Earnest money. A payment made to the seller to show serious intent to buy the property when signing the real estate purchase agreement. Depending on the purchase agreement terms, the deposit may or may not be refundable. A survey. As part of due diligence, the survey confirms the property boundary lines and any current or previous issues, title ownership, and other relevant details of those property lines. Addendum. This term refers to additional documents in a real estate contract. Addendums could include lead-based paint disclosures, seller's disclosures, these are a requirement, or property condition. However, addendums can also include modifications to the original contract. Then there are these special provisions. This part of the real estate contract allows parties to include clauses or other information not covered in the purchase or lease agreement, like leaving certain furniture or items behind. Mortgage note, a document outlining the mortgage loan terms and is signed during the closing period. Contingency clauses, requirements that must be met before closing. Common contingencies may include home appraisals or inspections, the buyer selling their current home, or financing approval. Closing costs. The seller incurs additional fees and expenses when completing a real estate transaction. The costs can include origination fees, processing, escrow, appraisal, title searches, surveys, and recording fees. Understanding how real estate contracts work is key to being a successful real estate investor. At first, terms used in real estate agreements can seem intimidating, but the more you go through it, the easier it gets. If you are looking to grow your portfolio and want a shortcut, I am an agent here in Des Moines, Iowa, and I can help take care of all of this for you. If you're an investor or looking to get into real estate investing, you know the importance of having good contractors in your corner. Hit the like and subscribe buttons down below, because in the next video, we go over how to find and keep good contractors. In the meantime, if you have any questions, please feel free to give me a holler. I'll leave my contact info down below. I look forward to hearing from you.